bump up my volume if I'm,
Okay, we're live.
all right. Good morning. This is Senate Judiciary. This morning is April 25th or 26th. Excuse me. And we're taking up S-230 first, and then we'll be taking up a bill on dram shop after a break. That's at H-288. So first is H-230, which is a bill having to do with prevention of suicide and community violence. So with that, Eric, I'm going to ask you to kind of walk us through the high points of the latest version that we handed out the other day. And Peggy, I don't see any documents on here for today. So
I did not put any new ones up there. I can.
if you just put up the new
New version. Yep.
version, because unfortunately I didn't bring, not expecting to be positive for COVID, I didn't bring any of my files home with me.
Yep, I can do that right now. Do you want to start talking, Eric, or it's just going to take a minute?
Yeah, you can start walking through, Eric. I think we already did this, but
Right, Senator Sears, Eric Fitzpatrick with the Office of Legislative Counsel. You're right that we did a walkthrough of your proposal amendment last time. Were you thinking maybe this time to focus on what some of the decision points were? I know you guys had talked about that last time, to sort of keep note of which issues you had to think about and discuss and reach a conclusion on.
Yep.
Does that make sense? Kind of take a look at those.
Okay, it's on the website now, Senator Sears.
great, thank you.
So I didn't know anything, and also, please interrupt and stop me if you feel like there's something that I'm either skipped or that you noted and wanted to discuss, or in any way I don't cover when I'm pointing out what I recall some of the decision points to be. So for example, in the section 1, the findings, I didn't note anything. It seemed to me that the committee went through some of the proposals in Senator Sears' amendment to strike a couple of the findings and portions of a couple of findings to replace finding number 5 with a more updated information from the Vermont Department of Health. So I didn't note anything, but I'll pause there in case anybody else noticed
Findings
something.
that anybody would like to either change or comment on or remove, or
I thought it was fine.
Same with the statement of purpose, in the sense that I didn't flag anything here. There was some change to the language that was recommended by the Attorney General's office to slightly tweak the purpose so that it's clear that it is intended to prevent death by suicide by reducing access to operable firearms by children and prohibited persons.
yep. Senator Wachowski has a comment, I think.
Yeah, so I wonder, given that we've changed the name of the bill and we're sort of looking at a broader scope of preventing suicide and community violence, if it makes sense to add that in here.
Yeah, I think so. Because otherwise we're expressly indicating purpose without that.
Right.
Yeah.
Good idea.
So within the statement of purpose, note the purpose about reducing community violence as well.
Yeah.
Yeah. All right, got it. Makes sense. Moving on. Sorry.
Wanted to give an opportunity if there's anybody in the audience, either on Zoom or in the room, who would like to comment on either the findings or the purpose at this point. Ben, we can't hear you.
Can you hear me now?
Yes.
Sorry about that. Ben Battles from the Attorney General's office. We had suggested the change in the purpose and don't have any objection to the modification that was just suggested.
Okay, great.
Thank you.
So moving on to section 3, which is the negligent firearms storage piece. Recall that this has been restructured to track the New Hampshire provision on negligent firearm storage in many substantive ways. I think that the one decision point that sort of is right there in the first line, my version, line 13 of page 4, was that it applied to a loaded firearm. I think there was discussion in the committee as to whether or not that was appropriate and whether the storage requirement, and again, remember that the storage requirement only kicks in the sense that there's only a criminal penalty if the storage requirements are not complied with, and then either a child or prohibited person gains access to the firearm and uses it to cause death or serious bodily injury or to commit a crime, that sort of thing. So just the simple act of not storing the firearm in the way that the statute requires is not a criminal act. So nevertheless, the criminal provision only applies on its face to loaded firearms. So in other words, if the firearm is unloaded, then it wouldn't be covered by this anyway.
And my problem with that is that if someone has a box of ammunition next to the gun and a prohibited person or a child puts a bullet in the gun and then uses it, it seems to me the person should face these penalties, but they could, with the use of the word loaded, they could get out from under that penalty. So I would suggest removing loaded, and then on page 5, the committee had talked about a sort of matching change where we would eliminate, but on page 5 near the bottom, the separate from ammunition, that's a way of being carved out from the penalty. It's not a mandate that you store it separately. It's a way of saying if you do store it separately, you're not liable. So I don't know that it makes sense to eliminate that, but that was something the committee had raised as a doing both things.
Yeah, I think we had discussed restructuring this in a way that like provided an exemption if the gun was locked. So if it was in like a biometric safe and loaded, that would be okay. But in every other instance, they needed to be stored separately.
Then I couldn't vote for it. I can vote for it with loaded out, but the idea, yeah. I mean, I think it gets too far down the road of going away from New Hampshire and Maine. If I'm fine with taking the word loaded out.
Okay.
Because, but I get into, you're back into it's common sense. If you want to put it in the warning, I mean, it's common sense. If a child or another person who's prohibited, and that's another problem, but I'll leave that for another day. But if we're saying it's common sense to keep your firearm separate from the ammunition, keep it locked or in safe storage or trigger lock. And if you do all that and you store it separately, and you're exempt from the criminal penalties if something horrid happens. But if you don't do that, then you could face criminal penalties for not being careful with the storage of the firearm. That's my understanding of this.
And Mr. Chair, to be clear, I agree with you. So I'm suggesting that we get rid of loaded. I was just noting that there was a suggestion last time to eliminate line 18 on page 5. I don't think that it makes sense to eliminate it because it takes away a defense that someone might have. It's not a mandate that they store it separately. It's saying if you did store it separately, you're not going to be liable.
Right.
So I would leave it as is and just take out the word loaded on page 4.
Thank you. I'm fine with that.
Okay.
Okay, and I just wanted to be clear that what I had remembered as part of the conversation in terms of an exemption was actually to allow someone to store their weapon loaded as long as it was locked.
And they can do that.
Under this, they can do that, because I think some of the discussion under this was actually that they couldn't do that because of the way the wording was to have it be stored separately.
And Eric, just check my understanding, but at the bottom of 5, these are defenses that someone might raise.
It's not a defense.
Or
It doesn't apply.
it doesn't apply.
So the way this is written, if my firearm were locked with a trigger lock and loaded, and for some reason something happened, I would still not be liable.
It's
No, I
in,
don't read it that way.
That's
no, it's in the safe.
Correct,
It's loaded and it's in the safe.
right?
It seems to me that they're not liable under this.
No, I think they are.
Okay. How come?
It's not separate from ammunition.
that
Ammunition
was,
is in it.
and that was where we
Oh,
had
it's
talked,
an and.
Yes.
that's where we had talked about an exemption for just that situation, if it's locked in a,
What about if we change the and to an or?
I don't know that would work, because then.
That would
Then
work.
would you be,
Then it wouldn't have to be it wouldn't have to be trigger locked.
right,
Or in a
you
safe.
could just put a gun on the table and put the ammo somewhere
Right.
else.
Right.
I see. Okay, well, maybe Senator Sears is right that we should just leave the New Hampshire model as is.
Let me just, I think I mentioned this last time, the New Hampshire model does not have line 18, does not
Oh.
have separate from ammunition.
right, and I think what I feel like is if it is not locked, it should absolutely be stored separate from ammunition,
Right.
but if it is locked, you've taken that aspect out, and what we've heard from a lot of people around the self-defense is
Yeah.
that those biometric locks make it quick and easy to access in self-defense. And so we had sort of talked about trying to carve out like an exemption just in that instance, if it's locked. And I don't know how to do that because I'm really bad at crafting legal language.
Well,
I,
Eric, if it's the feeling of the majority of the committee, and I'm fine with that, because we're not taking line 8, if we don't want to take line 18 out, then I think we should create the exemption if the firearm is loaded, but it's locked in a secure safe or something like that, whatever you call them, that it provides the same exemption.
I think, and correct me if I'm wrong there, now I understand better, I hope. If we get rid of 18, we will get what Senator Sears and
It's
Senator.
the easiest way
Huskey-
to do it.
Okay, so in that case, I would be fine with. So
But that,
in other words, as long as the person has the firearm in a locked container, it doesn't matter whether it's loaded or unloaded. If we get rid of 18,
but does that still keep in the bill that if it is not locked, it does matter?
yes.
Yes.
Okay,
Yes.
that's all I want to make sure. I don't want to just get rid of that if we're like, oh, now anything goes.
Has
So
to
I
be
get-
locked or in a container.
Okay,
So you'd move line 18.
Yeah, and remove loaded on page 4.
Right.
Yeah. So that was what we worked out last time.
okay,
We knew what we were doing.
perhaps.
Think next place where I heard some concern was in the warning. This kind of follows New Hampshire. Or kind of, it is New Hampshire. Or is it
Mhm,
Maine,
Yes,
Eric?
exactly. No, you're right, Senator Sears. That is exactly the New Hampshire one.
Yeah, I do feel like it's helpful here to name that someone could be liable if something, to explicitly call out that if you don't, not like, yes, this is good information, and if something happens and you didn't store it this way, you may be held liable.
If you took the last, line 15, if you took the last sentence, failure to securely store firearms as required by law may result and strike by law. If you failure to securely store firearms may result in criminal prosecution.
Yeah,
And we could make that the first sentence of the second paragraph.
Yeah,
So it would run into, it is important that you owner firearm, seek firearm safety instruction, blah, blah. Does that make sense there?
Times on a bridge, sorry.
So in other words, that sentence on 15,
Yeah.
so 7 through 11 is the first paragraph.
Mhm.
And then the second paragraph would begin, failure to securely store firearms may result in criminal prosecution. It is important, that would be the second paragraph.
Second sentence, you mean, or second?
So,
Keep the sentence and change it a little bit because
so this sentence
it's gone, right?
connects to this as a paragraph.
Oh, so you're keeping that sentence, is that?
Yes,
All right.
except
except as required by law. We cross out as required by law.
Okay,
And
Online.
then it's
gotcha. Also in the lines 12 and 13, you might have caught this already, but the separately from ammunition reference would come out since you're taking that out of the
No,
the
I
substantive.
think, no, we're taking out lines, lines 12 through 14 struck, I think.
Yeah, 12 through 15 and a half.
Yeah, 15 and a half.
Oh, okay, take out that entire sentence. Gotcha.
Yeah,
Yep,
The warning would read the failure to securely store firearms may result in criminal prosecution. It is important that the owner of a firearm seek firearm safety instructions from a certified firearms instructor and keep firearms secured from unauthorized use.
got it. Thank you. The only thing I had flagged other than that, that's previous to that, which you may or may not want to talk about, was the penalty provision. I think the committee had also, that's on bottom of page 4 and top of page 5. And committee was talking about the way it's structured now, it's a misdemeanor, 1-year misdemeanor. If the firearm is accessed and used by a child or prohibited person in the commission of a crime, or if they display it in a threatening manner, 5-year felony. If the firearm is accessed and used to cause death or serious bodily injury.
but not more than 5.
Correct.
Yeah.
Is that in addition to any other crime that may have been committed?
Yeah, generally that's going to be a matter of, courts can make decisions about whether sentences are going to run concurrently or consecutively, yes, but generally it would be separate from if the person were charged with some other offense as well.
Somebody went after stealing the gun, went into a school and did something horrid. They could still be charged with murder and the other thing, right?
Yes, absolutely.
And those are the penalties in New Hampshire?
No, the New Hampshire penalty was different. I think it's only $1,000 fine.
Okay.
I did do a little research about some of the other states though, and like Connecticut's is 1 to 5 year felony, $5,000. Delaware, 1 year, $2,300. Florida takes a similar approach in that also has a 5-year, $5,000 felony penalty for the death or serious bodily injury, whereas it's a 60-day misdemeanor for just using it in a interesting phrasing in a public place in a rude, careless, angry, or threatening manner. Yes, but similar structure in that it, the more enhanced penalty for death or serious bodily injury. Same thing in Washington, 5 years, $10,000 for personal injury or death, 1 year, $5,000 for using to intimidate another person or cause alarm or safety, or that sort of thing.
I'm fine with those penalties myself. Should we go to? I don't think anybody had any trouble with the county where the petition was filed. Or the eliminating attorney general.
Right? No, I didn't hear any either.
I think it was clear and convincing was the next place we needed to talk.
Right. So just to refresh everyone's recollection, you remember the proposal here is that in general, the ERPO emergency order, which is the 14-day ex parte order, the person can go in and ask for the order without notice to the person whose firearms it is, but it only lasts for 14 days. And within that period of time, there has to be a final hearing at which the firearms owner or whoever that other person is does get notice and an opportunity here to be present and be heard. Under current law, the burden of proof for the initial emergency order showing is preponderance of the evidence, more likely than not. So the proposal here is that, because remember, one of the things going on in H230 is to expand who can file for the ERPO order to a family or household member. So the proposal is keep the expanded ability of a family or household member to file, but for purposes of the emergency order, that ex parte one, have it be a clear and convincing standard of proof, which is the same standard, I forgot to mention, that applies for the final order. So that 6-month final order also has a clear and convincing standard.
Yeah, I have pretty significant concern with asking family members or household members who likely have no legal background to have a higher burden of evidence than someone who does have a legal background. I feel like ultimately what that does is make this unusable by a family member. So I have a pretty significant concern with raising this to clear and convincing. I don't think that that's going to allow this to actually be a useful tool, just given how high that burden is. And a family member, a household member who's filing for this doesn't just automatically get it. Like, it still has to be heard by someone who is a judge and has that legal background. But for me, this makes this not actually a useful provision.
Question for you, Eric. When it comes to relief from abuse orders, what's the standard that's used there? Is that also clear and convincing, or is it preponderance? Do you happen to know?
Not off the top of my head. I think that it's preponderance, but I'm pretty sure it's preponderance, but I'd want to double check.
Yeah, that's what I was thinking too. And one of the things that wouldn't make sense to me is that if you can apply for an RFA and there isn't necessarily that risk of firearms being involved, and it's a lower standard of evidence, but then firearms are involved in this ERPO situation, but we're creating that higher standard of evidence for the petitioner. I think that doesn't really make sense, because you're having a much higher risk of death or serious bodily injury when firearms are involved. So that's
if I might, though, it's an entirely different process. You're doing a relief from abuse order because somebody has been a victim of a crime. Usually there may or may not be a victim's advocate involved in helping that person. In the case of adding to the family member, I am concerned that there is absolutely no due process in the 14-day removal of the firearms. So this person who's the subject of the extreme risk protection order, again, extreme risk protection, means that person may be a danger to themselves or others. And I just feel like, because there's no due process until we get to after the 14th day, or sooner if the court hears it sooner, that it needs to be a higher bar. I don't believe we've seen this huge problem in Vermont that needs to be addressed, but it gives an opportunity, and the House wanted it in there. But right now, people can go to, family members, whatever, can go. And what I've seen so often, if you just, read the papers, somebody's arrested on Friday night. The bond is $300,000. Why on Monday morning is it suddenly $50,000? Why did it change? Same judge, because the judge is going to err on the side of caution when they're making that snap decision on Friday night at 10 o'clock at night when they're the on-call judge. And that same judge on Monday morning with more information frequently lowers or releases the person on their own recognizance after they spent the weekend in jail. How many times have you seen that happen? Time after time after time. And that is when people have been arrested on a weekend and the on-call judge is making the call or the decision. And that's the reason that I put in the clear and convincing for the family member, because there is no due process. It's an ex parte hearing. And that if you look at the record of the weekend appearance versus the arraignment on Monday morning or Tuesday morning.
All right.
Well,
No, I was just gonna say, I respectfully disagree that ex parte hearings don't have any due process. I feel like there's a lot of background that does support a lot of common law that shows that ex parte hearings within 14 days, unless there's you can have an extension of another 14 days, but it's my understanding there's a lot of background that shows that they are within that they do contain due process. So that's not something that I'm particularly concerned with right now.
Well, who establishes clear and convincing versus preponderance of evidence? I'm assuming the alleged victim comes in, gives his or her statement, affidavit, calls the workers to do an RFA, and with the ERPO orders, it'd be the same thing. Then they call the judge. The judge is the one you're not expected to come in and know clear and convincing answer. Just simply fill a statement out, tell the truth, the whole truth, not but the truth, and the judge will make that decision, clear and convincing or preponderance. So I mean, as you well know, I'm not excited about to begin this. I'm not really going to comment a lot, but I just don't think that. I think that clear and convincing is certainly the tool that we should be looking for here. The judge is going to make the ultimate decision, whether it's Friday night or a Monday morning.
Well, I'll just say that, there are things in this draft I like very much. There are things I don't like as much. I don't like this change as much as some of the other things, but I'm willing to go along with it because I think overall the draft is a good path to move the bill forward. So I can vote to keep clear and convincing if that's a sticking point.
Thank you.
I just really worry. I mean, we've seen instances where people call the police because someone is a danger to themselves and others, and someone with mental health issues ends up dead. And so people are afraid to call the police, which is our current way of getting one of these. And I just think that by putting clear and convincing in here, it makes it functionally a useless provision to a household member. Just, it's too high of a standard, especially when we have all of these other instances where we use preponderance of the evidence that are maybe not exactly the same, but somewhat similar. It just, to me, makes this change functionally not helpful. And I can't support that.
I do think at the end of the day, to repeat in some ways Bob's point or Senator Norris's point, a judge is going to be presented with some evidence as well, theoretically along with the person's story, and the judge makes the call. I've never been a judge, but I would imagine in that situation where you have somebody who's distraught and in fear and comes to you and has some way of corroborating what they're saying, I would think that it wouldn't matter so much, this particular standard, because they know there's in 2 weeks going to be another hearing where they'll have more evidence. So I would think that judges would tend to lean toward protecting the person who comes in. And I think the statistics bear that out in terms of how many go forward. But I take the point. It's you know, it's a way of setting a standard either lower or slightly higher. And this is the slightly higher one.
I just think that argument could actually be used just as much for why it should be preponderance. A judge is going to look at it and not have to ask someone to provide medical records or like, how do they provide that proof? Where do they get that on a Friday night when they don't actually have HIPAA access to someone's medical records and all of that background information? I mean, I think that the argument that a judge is going to look at it and make a decision is just as much an argument for why it should be preponderance and not clear and convincing.
Eric,
I don't even know why it's in the bill in the first place. The House put it in. If it were up to me, if I was the sole arbitrator, I'd have taken the section out. I haven't heard of a major problem in obtaining extreme risk protection orders for family members. Now there may be, but I've had about 1,000 emails and I've yet to hear one person, and I probably hear from somebody, but I haven't heard of a problem in Vermont. This is trying to follow other states' methods of using extreme risk protection orders. And here in Vermont, I've not heard this huge problem of going through either law enforcement, state's attorney, doctors. Last year, we put in a provision so that doctors would be clear that they could contact the state's attorney directly and not violate HIPAA if they found some problem with one of their patients. So again, if it were up to me totally, I'd take the whole thing out. I'm not sure that there's a problem here in Vermont. I could become convinced. We have RFAs. We've changed that in S104, S4. We even made that easier. So if it's a matter of abuse or something like that, we've got that system. So that, that's my opinion, and only my opinion.
Eric,
I was trying to find a compromised way to get through this for myself, and clearly there's a disagreement in the committee, and that's what committee process is all about, and I have no problem with that.
Eric, would you be able to just provide some sort of example as to what type of evidence a petitioner would have to provide when they're filing their proposal, if they had to use the clear and convincing standard versus the preponderance standard? Are there any examples or hypotheticals that you might be able to provide for that?
It's so fact specific,
Yeah.
and it's I can look into it a little bit. I'm not sure what we're going to come up with as far as being, maybe you could find a case in which there was a written decision that said if these 5 items of evidence constituted clear and convincing, and or maybe these other 2 items didn't make a preponderance, but I don't know, I can provide you a legal definition of each standard now, but
Eric,
the fact specific. Yeah.
maybe somebody can correct me, but I thought that the testimony from someone was that currently under the extreme risk protection orders, where it's preponderance of the evidence until you get to the final hearing, which is clear and convincing within the 14 days, about half of the orders are dismissed, or the firearms are returned to the individual. And I believe that was testimony we heard.
My memory wasn't that it was half, but that or maybe I'm remembering the number of initial orders that were okay. It seemed to me that one was, the majority were okay, but some weren't. Senator Sears?
Yeah.
I think the issue we're discussing is relatively clear. I think people know their minds about it. Could I suggest that we straw vote on this piece And then,
Bowski wants to
Senator
comment.
Bohofsky has a question. before
oh,
that.
sorry.
That's okay. My understanding of that statistic was that there was some percentage that the final order wasn't sought, but we don't know if that is because the person has been hospitalized or if that's because the person has perhaps involved in it. Like, we don't know why that is. We are jumping to an assumption that that's because everything was fine and they just got their guns back. Like that, there, we don't have any information as to why the final order wasn't sought, and that may well be because they're now hospitalized because of their mental health condition, or they have been found guilty of a crime, and are like, we don't know why that percentage of the final orders aren't found. Like, we are leaping to conclusions to say that that's because the initial one wasn't valid.
Okay. Well, Senator Baruth has suggested a straw poll, and I would vote for clearing. Darn, why is that doing that? I would vote for clear and convincing.
Times two. Clear and convincing.
And I've said I would support that in line with the compromise nature of the amendment as a whole.
I can't support clear and convincing. I would vote for preponderance of the evidence.
Yeah, you know, really on the fence about it. But knowing that the majority of other civil cases utilize preponderance of the evidence, I would prefer sticking with preponderance of the evidence. But I do appreciate the hearty conversation we've had about it.
That's 3-2, I believe.
Yes. I would also say that compared to current law, I think this will be better. This will allow more. I can't believe it would be entirely useless to make the change. So, although I respect it, feel it.
Well, the next issue in the bill, nothing changed, but I want to make clear I didn't change it because 72 hours is in the House bill. I have yet to be convinced that 24 hours isn't enough, which is what I voted for 3 years ago. The governor vetoed. So I'm expecting that if we leave it at 72, the governor will veto it again. I have no reason. I have no knowledge of that, but since he vetoed 4,
Well, I thought he vetoed 24, saying that there was no evidence to support 24. That was my recollection, but I could be wrong about that.
I think that was what he said, but I don't think he meant 72.
Well, I think that there is evidence to support 72, so I think it does answer
Well,
the
what-
concern voiced. You know, the lowest number any other state uses is 72, and they do see when they use 72 that there is a reduction in suicides and other crimes that are sort of in the moment. And so I think that given that 72 is already the lowest any state uses, that is the only place where we have any evidence that it is helpful. I mean, many states have a longer waiting period than 72, and I think there may be evidence that longer periods are more helpful. I don't know. This is not an area where I've done a deep statistical dive, but there is evidence that 72 hours is helpful and protective.
Well, there was evidence from various, and this was just on suicide. I can't speak to community violence, but there was evidence that suicide would be reduced by a 24-hour waiting period. Those who are impulsively seeking a firearm to purchase, usually, I can't remember all the statistics, but it was a couple of gentlemen, I think from MIT, who had done extensive research throughout the nation.
Senator Sears?
Yep.
I'm wondering if I'm reading your intention right. So your amendment leaves it at 72 hours, but you've personally expressed of
If
a
we were
desire-
doing if we did a straw poll, I would vote no to 72. But I left it in the amendment because I didn't think I'd get 3 votes. To be honest with you.
I believe you're right on the numbers.
But if you want to have a formal vote, I'm suggesting no on 72, and maybe we could do that, and just have a discussion about that.
I think the other elegance to 72 is that it aligns with our other mental health protection laws. You know, you're allowed to hold someone in a mental health facility or a hospital for 72 hours if they're deemed to be a risk to themselves or others before you need to go through the court order process. So I think there's an elegance here too, in that it aligns with existing mental health protection law.
Mhm.
Yeah, I was just also gonna say, I mean, I like 72. I mean, there's the question that I've had from the beginning is, you know, where is the background and the research to support that? And there's other states that we've talked about that have these waiting periods for 72 hours. They've seen a reduction. And then what Senator Bohosky was just speaking, that's another supporting point for me. So I think 72 hours is fine.
And I would add, I like 72 hours for all of the above reasons. To go back to what Senator Hashim said about the governor's veto message, it was, I will say, disingenuous, is the gentlest way I can put it. In other words, I felt as though the governor was attacking us for having gone for less than a 48 or 72 hour period at the same time that he was attacking us from the other side of the issue. So in some ways, I don't know that looking into whether the bill would be signed is a way we should be operating. That was an attempt to send him something that was palatable to him. But if we're going to judge by research and by other states' bar, at 72, we would have the least amount of time on statute. Whereas if we went to 24 or 48, we would be way out of sync with all the other states. So I think 72 makes sense, and I would vote for that.
I guess I'm supposed to comment now. Basically, whether we're talking about 24 hours or 72 hours, I'm not in favor of any waiting period for the purchase of firearms. I can assure you that many of my constituents that I represent have reached out to me, and they are not in any support of a waiting period within the Franklin district. So for the lack of a better term, I guess I'm not even going to say that, but I will oppose any waiting period for the purchase of firearms.
I already have a record of voting for a waiting period, so I can't say I'd oppose any, but I voted for 24 hours based upon the information that I had in front of me. But I cannot support 72. So I think that's a 3-2 vote of straw poll of the committee on the waiting period. I guess the last section is severability.
Well, there's also the pressing question of whether we want the title to be an act relating to an act relating to an implementing mechanism.
You didn't vote to keep that.
I think we get 5 votes to change that, Senator.
I don't know.
An act relating to an act relating to. Yeah.
If there are no points of discussion about the severability, which looks pretty standard to me,
Right.
I'm wondering if you would entertain a motion, Senator Sears.
I just
Would.
want to quickly point out that under, can you find it, section 3, it would be D 1 and 2, the warning. I support that 100%.
Okay, nice.
The signage,
Excellent. I like
I
it.
try to do what I can.
Not sure if you heard my question, Senator Sears?
Yeah, we can vote. Is it draft 2.1 or 1.2, Eric?
That's a good question, Senator Sears, because this was a proposal amendment from yourself. So it would not, I assume it's going to be a committee strike off.
Yes.
Right?
Now it would be a committee strike all.
In that case, it would be 2.1.
Okay. So Senator Bruce has moved that we amend H230 as seen in draft 2.1 that was just discussed for the past hour. Is there any further discussion from anybody in the audience or anyone on the committee?
We do have one, Rebecca is raising her hand, Senator Sears.
Yes, okay.
I just wanted to note that the significant departure still from New Hampshire on the penalty front, right? This is, I hear it's still including a 5-year felony based on strict liability offense. It's also departing from New Hampshire by including prohibited persons instead of just children, more broadly defining children. And so I just, and then also expanding to unloaded versus just the New Hampshire bill is limiting to loaded. Combine all of these three things, I still think you have a fundamental unconstitutional section 3 in the due process.
Thank you.
Well, thank you for that. I appreciate that. But I realize there's some departure from New Hampshire, but I think it's much different from the bill that was brought to us. And I think it might pass constitutional muster, but I'm not as knowledgeable as you are about the Braun decision. But I go by what Council Fitzpatrick has told us, is that nobody knows for sure what is and what isn't. But I suspect the original version that was passed by the other body would probably not stand constitutional muster. And I think this has a better chance, but we will never, we won't know until it comes up. But I don't see the Supreme Court striking down Maine and New Hampshire, and I realize there's a departure there. But thank you. Any other comments? Okay. So Peggy, would you please call? This is on the amendment. So
We
Yeah.
need to adopt the amendment first.
I think that would probably be proper. So Peggy, would you call the roll on the amendment?
Senator Baruch,
Yes.
Senator Norris,
No.
Senator Bihowski,
Yes.
Senator Hashim,
Yes.
Senator Sears.
Yes, and I want to explain my vote. I've learned over the years that 2 out of 3 ain't bad, to quote Meatloaf. And so that's why I'm voting for it. I don't support the waiting period, but I do support the other 2 sections of the bill as they've been amended. So I'm voting for the bill. Okay, is there any, Senator Baruch further moved that we report the bill favorably as amended. Is there any further discussion of that?
Not seeing anything in the.
All right, thank you. Peggy, would you please call the roll?
Senator Baruch,
Yes.
Senator Norris,
No.
Senator Bihowski.
Yes.
Senator Hashim.
Yes.
Senator Sears.
Yes. Senator Baruch, would you like to report this as you've done countless times?
I would be delighted.
I will make some remarks on the floor about the bill though. I would assume it's going to be up Friday.
Yeah, if it goes up to the Senate Secretary today.
Well, I'll leave that to you and Eric to work out because Eric's got to redraft some of it.
Yeah. Well, we can talk about the exact timing, not maybe Well, I'll take it up today and then we'll talk about when we do it.
Okay, that's fine. I'm no problem with, I'm hopefully I'll be back on Tuesday in person.
Okay. And Peggy, I can take that up.
So we get it from there.
Yeah, it's gonna be a while,
Okay,
till late in the afternoon, probably.
yeah, no problem.
All right, what time, Peggy, are we scheduled at 10:30 for the other bill?
No, 10:45.
See if you can move it up to 10:30.
Okay, I can ask Tucker.
35 minutes is too long a break.
Senator Sears, just.
My dog doesn't think so.
Just to give you a heads up, I was hoping to step
Yeah.
out at 10:30 just for 5 minutes to meet a elementary school
Oh,
group.
no problem.